Good morning, Dumelang, Jambo, Salams. Thank you for taking the time to join us today. We are hoping to use this event and this discussion to start a debate towards formulating an African response to the second revised draft. My name is Tshepo Madlingozi. I teach at Wits University, where I also direct the Center for Applied Legal Studies. For over 40 years, the Center for Applied Legal Studies, together with our partners, has been engaged in holding states and corporates accountable for human rights abuses. We are delighted to be co-hosting this event with the Center for Human Rights, UP, together with the African Coalition for Corporate Accountability, ACCA. ACCA is a Pan-Africanist coalition of over 140 organizations, human rights activists, social justice activists who are engaged with supporting communities that are faced with corporate abuses, that conscientize states and social movements on corporate accountability and how to enforce that. But for purpose of this event, ACCA is also actively involved in formulating an African response to this treaty. We have assembled a stellar lineup of human rights activists, academics, state officials, as well as people who are directly involved in this treaty to help us to make sense of this treaty. In the first place, we are hoping that our speakers, together with you as engaged listeners, will help us unpack this draft. Is it a step forward and 2 steps backwards, or is it the other way around? But also understanding that a treaty or any legal mechanism by itself can never dismantle corporate power, can never disrupt neoliberalism and neocolonialism, which are the very sources of corporate abuse and corporate impunity. What is in the treaty that can enable social movements and lawyers to use it as but one tool in disrupting the toxic coalition between state and big business, but also in terms of holding corporates accountable. In the final instance, we want our speakers, together with yourself, to look at this treaty from a gender perspective, but most importantly, from an African feminist perspective. What is in this draft that responds to some of the shortcomings that were there in previous drafts? We know that corporate abuse, corporate impunity impacts disproportionately on women and gender non-confirming people. So is this draft a step in the right direction in terms of gender justice? For us, only an African feminist lens will enable us to understand and analyze this treaty from an African perspective in order to respond to our unique challenges in Africa. Challenges of land grabs, challenges of extractive industry and related displacement, climate injustice, state capture, neo-patrimonialism in Africa, but also, of course, an African feminist approach and movement building will enable us to understand this treaty from that kind of perspective. So we are hoping that as the speakers are speaking, you'll be posing your questions, you'll be engaging with us so that we make this an interactive event. I want to thank the organizers at the ACCA Secretariat. I want to thank our partners as well as our funders. I will now hand it over to Abi to continue the program. Thank you.
Thank you very much for your very brilliant introductions, Tshepo. And you've already relayed the background for this very important webinar, which I'm hoping would also set the tone for Africa's participation in the binding treaty conversations that have continued. Africa's antecedent in our history in the past 300 years is linked to all sorts of atrocities. And of course, most of them are related to business and human rights. Our very colonization was about human rights violation. And there've been a lot of conversations through the centuries and in more recent years, in the past 50 years, in the past 20 years, and more recently, since 2014, calls for us to have a binding treaty on business and human rights so that we will no longer have a situation in which corporate accountability is voluntary and not not guided by any rule of government. As most of you would know, that the world's largest companies received an average score of 15% for their remedies and grievance mechanisms in the corporate human rights benchmark latest ranking in 2018. And this is not good enough when you think about how our countries are largely capitalist countries and run on these issues. And when governance is weak, these are bigger issues to deal with. But what's the African perspective? Most of the businesses go on in Africa, most of the profits in the Western world. More vulnerable than any other continent is the African continent. And with me today to speak to these issues and to deliberate on the most vulnerable people and the most important aspects of what the binding treaty should look like and the direction for Africa itself are our panelists, and we've got 5 of them. The first being Professor David Bilchitz, who is a professor of fundamental rights and constitutional law at the University of Johannesburg and director of the South African Institute for Advanced Constitutional, Public and Human Rights and International Law. You're welcome, Professor David. And also, of course, from Uganda is Mr. Arnold Kwesi, who was project coordinator at the Ugandan Consortium on Corporate Accountability and has done extensive work on the binding treaty for this continent. You're welcome, Arnold. Ms. Falogin Amuno, who's the Building Feminist Economies at the Associate for Women's Rights in Development and Feminist for a Binding Treaty, who will speak to us today about the feminist view for a binding treaty, is also on the call with us this morning. Professor Gitu Maigui, and forgive me if I've killed your name. I should have learned the proper pronunciations before this webinar. Is Associate Professor of Law at the University of Nairobi and member of the United Nations Working Group on the issues of human rights and transnational corporations and other business enterprises. And if you know anything about the University of Nairobi, you also know that they've done extensive work on the binding treaty. Finally, but not the least, is Ms. Gladys Pickering, who is Deputy Executive Director at the Ministry of Justice at the Republic of Namibia, will also be speaking with us today. I think we should go straight into this, and starting with Professor David Bilchitz, who will be speaking immediately on reflections on the second revised draft of the Treaty on Business and Human Rights. Professor Bilchitz, you have the floor.
Greetings. Thank you very much to the chair, and thank you very much to CALS and ACCA and the Center for Human Rights at the University of Pretoria for organizing this forum. I just want to check if you can all see the screen. Can you see the screen? Okay, that's fantastic. Great. So I'm going to present, I've been involved in sort of advising on the treaty and the content of the treaty, so I'm going to engage with that. And to start off with, just recap a little bit about the need for a treaty. recognizing that why do you have a treaty? Well, the idea of a treaty ultimately is to address some issue that exists, of course, a social issue, but also, particularly in this case, gaps in international law, right? There are serious gaps that have existed created by globalization. And ultimately, I frame the goal of the treaty as being to address violations of human rights and trying to advance their realization. Now, I'm not going to recap the whole process because I think many people here know the process, but it has been already a relatively long one. There is a long history of business and human rights at the international level, and I'm also not going to recap that, but just you can see here the resolution to commence such a process began in 2014, and then there were 2 years of collecting ideas, and then there was a document called the Elements. There was the 4th year we had a 0 draft, the 5th year the first revised draft, and now we have a second revised draft. And the question ultimately, and I'll address towards the end, is how much longer do we need to wait? And how long is this process going to actually take? And how do we get some kind of momentum around the treaty? So in terms of what I'm going to present to you on, this is the structure. What kind of treaty do we have? I'm firstly going to say to you, what is the draft on the table? Secondly, what are the serious omissions currently? Like, what has it not done? Because I think that's quite important for us to understand, and whether it kind of addresses some of the issues as has been discussed from an African and African feminist perspective. Okay. Improvements to the text. I won't go through these in all detail. I will just highlight a few main issues. As you're going to see, in some ways, I think we have a relatively good text for the purpose of which the treaty has been drafted. And actually, we should be negotiating on the smaller points. So I can't go through that in detail, but we can have a bit of a discussion around that as well if people want to go on. And then I will reflect at the end on the way forward. So what kind of treaty is on the table? Well, the first thing is I think we have a treaty focused ultimately on trying to enable victims of rights violations to gain access to remedies, right? That has been quite difficult to achieve. There are a range of reasons why corporations have been essentially able to benefit from a kind of impunity, from weak regulatory systems, states unwilling to enforce their own laws. And essentially, this is an attempt to empower communities and individuals to be able to gain remedies where they have violations of their rights by corporations, and to remove key legal obstacles that have been seen to exist around this. So that's the one objective. If that's the purpose, that's one objective against which to evaluate the text. Does it actually achieve what it's meant to achieve, right? Does it actually make it easier for victims to gain access to remedies, right? The second big prong, I think, is to try and not just give remedies when a violation has occurred, but to prevent violations. And one of the key aspects of the treaty here is to essentially place on states an obligation to make the human rights due diligence process mandatory, okay? That process whereby companies have to investigate, understand their impacts, prevent the impacts, try and mitigate them where they occur, and remediate where they have done wrong, okay? And essentially that is making that an obligation, right? And states making it an obligation. And this is a key dimension of the treaty because it's an attempt to prevent violations from occurring, okay? And effectively imposing a corporate responsibility in an indirect way to take steps to understand these impacts. So those are the two things I think that are at the heart of this treaty, right? And that we have on the table at the moment. What doesn't it do? What are the key omissions? The first thing it doesn't really do is it has no operational provision that directly engages with the question of corporations and their human rights obligations. It does not clarify those obligations. And I've argued that that's one of the things that a treaty should have done and could have done. Not exhaustively, but it could have laid out at least general principles in this regard. And I think this is a big hole. The treaty should have some language, at least recognizing that corporations have obligations, in my view, the full range, although they are modified. It's a complicated issue. I'm writing a book on this, but they have a full range of obligations to respect, protect, and fulfill rights. It doesn't mean they have exactly the same obligations as the state. but they do have obligations in this regard. They're not formed just to make profits for individuals. They formed as societal institutions in a certain way, okay? So why is this a big hole? Well, the first thing is I'm not convinced that human rights due diligence makes a lot of sense without having some idea of what you must do diligence about. If you don't really know what your obligations are, then really, well, I'm looking at my impacts, but what impacts are allowed and what are not allowed, right? There seems to be a problem over there in conceptually. And of course, it might be that indirectly we come to understand obligations through due diligence. That might be one idea that happens. There's also a problem with remedies. How do you give remedies where you don't have an understanding of what obligations are of corporations, right? So as I've said, the solution to this is possibly it will be developed as implicit in existing provisions. I think it's still worth civil society pushing and making a demand for some kind of language around direct obligations. Whether that's politically feasible or not is a debate, right? And it may ultimately not get in, but why should we necessarily go all the time with what's feasible? We need to go with what we think is correct from a fundamental rights point of view. Right, so we need to make that case. If governments cut back on it, well, they cut back on it, but we need to say what's necessary, okay? Second big problem, lack of an enforcement mechanism, right? The main enforcement mechanism in the treaty is really through civil law, and it relies on the legal systems of countries, which are variable. And ultimately, one of the things the treaty does is it allows a home country, a space where a corporation is incorporated, for example, to be a jurisdiction where the company is sued for violations in another country, right? Extraterritorial enforcement. The committee that's formed considers state reports and issues general comments, very common things in international committees that have existed, although these are under review at the moment. But there's no real powers to investigate issues from a start, right? Kind of a minimal requirement, or accept individual complaints. Okay, without those things, I don't think we fully plug the holes in accountability, okay, because there's always going to be great difficulties involved in extraterritorial judicial enforcement. And the last big hole, I think, is the lack of any discussion of corporate law in the treaty. For human rights to be taken seriously, we need ultimately to think carefully about the decision makers within the corporation. And I've argued in some work, and I'm currently working on, we need to think about the fiduciary duties of directors, these kinds of issues in corporate law, which maybe fundamental rights people don't engage with a lot, but they're absolutely critical. Do directors have a duty to think about fundamental rights? What reporting obligations do they have? And what accountability do they have for their decisions? Okay, there is a general obligation in Article 6.1 for states to create legal frameworks that support essentially fundamental rights, but there's no real engagements with the legal specificities of the corporation, which render it easier for impunity to reign. And I think that's disappointing. I've made these claims at the Intergovernmental Working Group. There just hasn't been really taken up. So that's what it doesn't do. Okay, what about what it does do and the improvements we can make to text? Well, the first issue is one of them that's been quite a divisive issue, which is the question of scope, right? Does this treaty just apply to transnational corporations, or does it apply to all corporations? Okay, and the EU position was it should apply to all corporations. The countries that actually promoted initially the resolution actually limited to transnational corporations or whose activities have a transnational character of a kind, okay? And essentially the current draft effectively kind of gives something to the EU, right, to try and bring them into the process, and says, well, it will apply to all corporations, okay? Now, this debate in some sense is quite frustrating, because actually most of the provisions of the treaty and the gaps in international law relate to companies that cross borders. That's where it actually most of the treaty is meant to give effect to. At the same time, most people accept that there is a state duty to protect from violations against human rights violations of companies in domestic jurisdictions as well. No company at all, even a domestic company that's only based in one jurisdiction, can claim a right to violate rights. So it seems to me that there's a lot of this is being pushed as something to drive a wedge between countries, but there's an easy compromise position. And my proposal was, actually, we don't even necessarily need a provision on scope, but ultimately what we need to do is have a general principle that all businesses are subject to obligations to respect, protect, and where applicable to fulfill rights. That's not controversial, right? Or, well, the obligation on businesses may be controversial, but you can say states must impose those obligations. That's not controversial, the state duty to protect, okay? And then essentially you have the human rights due diligence prevention obligation being applied to all business, which I think is an important part of the state duty to protect. And then the rest of the treaty effectively is going to apply to transnational corporations, because part of the legal gaps are really about being able to bring cases in other jurisdictions. And they really apply to transnational corporations. So I think there's a deal to be done on this, and actually one that doesn't cede too much ground on either side and actually realizes what we are concerned about addressing the gaps in international law. Human rights due diligence. That was one of the issues I said to you is one of the core dimensions of preventing. Well, one very area I was looking again at this, and one area of unclarity is it says, well, once you identify human rights abuse, you must take measures to prevent and mitigate that abuse. But if you start thinking about it seriously, prevent and mitigate are quite different. Prevent is actually stop it. Mitigate is reduce the impact that it has. Okay, and it doesn't really say when you must prevent and when you must mitigate. Okay. So again, this is part of the problem of not really clarifying what must be done, and that if that's not changed, it will need to ultimately be clarified by some kind of committee or courts. On conflict zones, this is obviously a serious issue where companies are involved and often involved in abuse. There is a talk of enhanced human rights due diligence, but that's not really elaborated on, and I think there needs to be some more thought around that. Okay. And states are required to ensure effective national procedures to ensure compliance with human rights due diligence. Again, very, very vague language about what is actually required. Again, some vague language is necessary at a treaty level, so I'm not saying everything must be absolutely specific, but it's a question of whether that's adequate or not. Okay. On jurisdiction, there's some issues, as I say, I'm going to skip, like the criminal provisions on the treaty on legal liability. There are some unclarities about what criminal offenses under international human rights law means. On issues of jurisdiction, I think one thing that's lacking at the moment with jurisdiction, it allows this company to be sued where its principal place of business is or where it's incorporated, but it doesn't necessarily follow the assets of the company. And that's a key thing, that companies are very good at hiding their assets. Okay, so I would suggest one proposal is to is that jurisdiction should be able to be held where a company's predominant assets are held, not just where it's incorporated, which may be quite a different jurisdiction, for example. Okay, the forum non-convenience rule, I don't want to go into this in detail, but the current provision really attempts to do the impossible, use a treaty provision to repeal a domestic law, and rather it needs to impose obligations on states to repeal laws, allowing court to decline jurisdiction on grounds of there being a more appropriate forum. Applicable law, it must be clear that the law that is applied, it currently suggests there's a victim's choice, but it doesn't say if the court has to give effect to the victim's choice. I think that should be made clear that it's mandatory. The mutual legal assistance provisions, there's one provision which is particularly reduces the value of the treaty, and it says mutual assistance may be refused if it is contrary to the legal system of the requested state party. And that just weakens the provision hugely, because actually often you want extraterritorial jurisdiction where there's a weakness in the system of the host state. And it's also against the actual international law, which says that you can't use domestic law to justify a failure to fulfill an international law obligation. And there are also state sovereignty provisions which are problematic. On the committee itself, I would suggest there's a need for a mechanism to avoid corporate capture of the committee and avoid conflicts of interests. There needs to be an addition that the committee has a power to develop principles for understanding the implications of fundamental rights for corporations. I've suggested the need for investigations as well. There's obviously a question about an optional protocol, an individual enforcement mechanism, and the fund and how it's funded to support victim claims, and whether a percentage of any award from a court, for example, should go to the fund or etc. Okay, I should also say that these comments, I just want to acknowledge that part my own, but they also come through reflection that we had a meeting arranged through my institute, SAIFAC, a number of weeks ago to discuss this, and some of these reflect other comments as well from a range of civil society across South Africa, and that's much appreciated. So how do we go forward from here? The treaty, as I've said, is not as ambitious as many of us would have liked and has some serious admissions, but it still plays a useful function in terms of the prevention obligation and enhancing the access to remedy. I've suggested some improvements, and it can certainly be tweaked, and there are others. But overall, as Professor Surya Deva has said in a recent blog, the treaty, I think, is ready to be negotiated. It's ready for states to get involved in finally negotiating it. And the question now is how to develop the political will to finalize it, adopt it, and ultimately open it up for signature. Well, there is clearly a divided world on these questions, and there is some signs of hope, particularly in the global north. Well, we don't know exactly what will happen, but there is the possibility, obviously, in the United States of a new administration. We don't yet know what's going to happen there. The EU's also started talking about mandatory due diligence laws in the EU, and Germany has started talking about that. That is important and may make them more amenable to the treaty to ensure that their businesses are not at a disadvantage from others in the world that are also required to meet these requirements. Ultimately, the path to advances in fundamental rights is not easy. From the abolition of slavery to the demise of apartheid, obstacles initially seemed overwhelming. And advocates for these changes in these areas and others need to recognize the deep flaws in the status quo, and ultimately, as civil society, in my view, doggedly pursue principled change until it comes about. So we shouldn't see this treaty as the be-all and end-all. We should also see the gaps that are left and still continue fighting for them. In order to get this treaty over the line, there will clearly be a need for coordinated campaigns in both developed and developing countries, and we're going to need to work on those together. And in my view, very importantly, will be to encourage leading developing countries like India and South Africa, which are amenable to corporate strong obligations. In our constitution in South Africa, we have it clearly recognized that juristic persons have obligations to lead the way in the developing world. And for those interested in more detail on what that treaty could contain and some of the details that haven't necessarily been included, there is that book that I edited with Professor Surya Deva on building a treaty on business and human rights. And I also wrote an article called The Necessity for a Business and Human Rights Treaty, just arguing for what the core reasons are behind the treaty. So those are a few of my reflections at the moment, and I look forward to hearing the other presentations and engaging in the discussion. Thank you very much.
Thank you very much, Professor Bilchitz. That was very, very brilliant. You managed to cover the entire gamut of the draft treaty in minutes and to expound on it with such brilliance. But I think that get a deeper, and you had started to talk about the developing countries' perspective to the treaty. But I think that let's go deeper into what civil society needs to do in Africa. And to do this, I'm going to invite Mr. Arnold Kwesi to speak on assessing the second revised draft from an African civil society perspective, and then we can start to debate in a few minutes. Kwesi, you have the floor.
Okay, thank you very much, Abi, and thanks, Professor David. He's really comprehensively highlighted the number of issues that I personally was looking at from a broader academic perspective, but also reflecting on exactly how they impact the broader realization of human rights, social and economic, from a business activity context. One of the things that we've been engaged as civil society, but also as different human rights advocates working around social and economic rights, we can't really talk about business and human rights and corporate accountability on the continent without looking at the two prongs that it has come with. A lot of it being pushed by our own states as key, looking at business and investment projects and other development projects as key areas that are going to drive the economies, but also looking at them as a push to realize a lot of human rights. But one of the things that we continuously see is that most of the business, and it's really evident, most of the businesses and engagements on the continent have been associated with increasing abuses and violations of human rights. And these are anchored around, global conditions that we have also discussed within the EACR working groups, because you have continuous increased, repression, growing repression, because a lot of the businesses and development projects tend to come with mutualization or securitization of these projects. We have environmental degradation at its highest on the continent. We have depending inequalities, dispossession and impoverishment, but also corporate capture, state capture, and Professor David talked about it, where we're really struggling as a continent, even as civil society, to push for access to remedy or to push for any remedial mechanism, largely because of the different institutions and mechanisms that are put in place to address, to regulate and set standards, have been captured by massive transnational corporations and multinationals. And also at the head of it all, and within a bit of corporate capture, is the popularity of corporate social responsibility and community manipulation. What we see, because of failure of the state to provide essential basic services, and what you get to see is a number of companies coming into place and offering these services, but in a way, through their corporate social responsibility engagements, but in a way manipulating communities to justify some of the abuses and violations, but also as a way of trade-off for accountability. So all you see is all these issues are compounded by inexistent and ineffective access to remedy mechanisms. We continue to see a number of states' national development agendas remain largely focused on creating conducive environments for private actors to do business, but also creating this narrative that economic development and human capital development is only going to be achieved through private sector led development. So there is a huge challenge between balancing the attraction and promotion of investment and development project and respect for human rights. And some of the things that Professor David has talked about is what we continue to see and fight as civil society, because on the continent we are struggling, if I may say, because everybody knows the shrinking space for civil society actors. When it comes to business and human rights specifically, we've been, I come from an environment where we've been called anti-development or economic saboteurs, in a way to kind of shut out civil society around discussions on issues to do with business and human rights. But when you go specifically to the second revised draft, and I will try to not repeat things that Professor David has talked about, but without a doubt, we can say there's progress that has been made when it comes to the revised draft. We see a lot of new reflections, a lot of things, issues to do with gender perspective being highlighted in the draft. We continue to see more concrete affirmations around human rights defenders and where that is where civil society falls into place. We continue to see situations of where state-owned companies are being mentioned now directly, and because those are areas that we've been struggling with. But also there are key areas that remain not strengthened, because they are really critical if we are going to have a treaty that addresses the key problems that we have continuously been speaking about at different sessions. One of the key issues that we should not forget is that a lot of the development and discussions around a treaty on business and human rights, or a legally binding instrument, was due to the failures of largely Pillar 3 of the UN Guiding Principles on Business and Human Rights around access to remedy. So we see, and I agree with Professor David, we see a treaty that is trying to address issues to do with remedy a lot, but also issues to do with prevention. From an African perspective, and one of the things that we've been fighting with, it's kind of very regrettable that we have a treaty that does not speak around illicit financial flows, because they are really a huge challenge when it comes to the continent. And it's really important that we have a discussion around how we come up with a legally binding instrument that addresses or speaks to illicit financial flows, because the amount of financial repatriation suffers annually is beyond what people can comprehend. And this is one of the discussions that we really had at the last session in having a discussion on the treaty from an African perspective. And within that discussion were the illicit financial flows. And it's really, like I noted, regrettable that it's not again being reflected on within the treaty. So it's really important that the treaty discussions within civil society, but also other actors working around the binding treaty provisions around illicit financial flows. Another bit that is lacking that we have been on, or we have been pushing as civil society, a lot of abuses and violations within business activities on the continent tend to happen within the informal sector. We have a huge informal sector, and if I speak from the perspective, percent of workers fall within the informal sector. And the challenge is that even within that framework, they are not largely protected by the domestic labor rights frameworks or workers employment laws and other labor rights laws, because they tend to work within an informal environment of contract. And it would really be critical to have a treaty that is very that makes provisions for labor rights specifically, but also speaks largely within the informal sector, because that's where massive abuses and violations of human rights tend to arise, and the challenges around remedy tend to be most evident. Like I noted also earlier, it's really important. It's really good that the treaty, the second revised draft, makes provisions for human rights defenders and speaks to them from an angle of from both areas within the prevention, but also rights of victims, because they're looked at as victims. But also it's important to strengthen provisions around human rights defenders, because that's where civil society would fall in, because a lot of abuses that tend to happen within the business and human rights angle tend to happen in rich, rural, or involving a lot of illiterate and sometimes rural communities. And their clear avenue for defense tends to come from civil societies and community-based organizations that tend to support their work. And so what we have continuously seen is that a lot of companies and a lot of government agencies tend to target human rights defenders. And so a strengthened protective cover for civil society and human rights defenders should be, kind of put in place or incorporated largely within the treaty, because it's the only avenue that we're going to have a more clear implementation strategy, but also enforcement from an angle that those that are fighting for corporate accountability don't fall under the whims of the state agencies and corporate power. So going directly to the treaty, to the revised draft, and looking at specific issues that tend to speak to our work, but also how it affects civil society engagements on the continent, but also corporate accountability on the continent. One of the key issues that has been pushed throughout the process that I think from the first time I engaged with the binding treaty discussions, that was in 2016, it was at the top, and the challenge is that it keeps coming in and out in one way or the other. But the importance or the primacy of human rights over other trade and investment agreements is one of the key issues that needs to be expounded within the treaty, because a lot of the things that we face on the African continent is that most business large transnational corporations, but also multinationals, tend to operate within a landscape that has bilateral and multilateral international agreements that sometimes waive access to remedies in a way that unless you're in a state, private individuals cannot push for access to remedies. So it is important that, yes, the provisions are there, but it would be really that we have a provision within even the preamble that specifically talks about the primacy of human rights over trade and investment agreements, because this is critical on the continent if we are going to have a tool that is going to strengthen access to remedy for business and human rights violations. Like I said, Article 14 on the revised draft talks about some of these issues, but as existing bilateral and multilateral agreements, but also new bilateral and multilateral trade and investment agreements. But we think it's really important that this provision is clearly stated within the preamble as a way of strengthening access to remedy mechanisms and also holding abusers of economic, social, and cultural rights in the context of business activities accountable. I can't emphasize enough the issue around human rights defenders because it's really, really critical. And like I said, it's a welcome move that the preamble emphasizes it because it talks about, civil society actors and human rights defenders have an important and a legitimate role in promoting the respect for human rights by business enterprises and in preventing, mitigating, and seeking effective remedy for business-related human rights abuses. And the same is really kind of enshrined in Article 5 around protection of victims, because it talks about, state parties taking adequate and effective measures to guarantee the safe and enabling environment for persons, groups, and organizations that promote and defend human rights and the environment. And so it's really a discussion that we need to be pushing to ensure that there are more strengthened provisions within the treaty, especially borrowing from already existing human rights instruments like the UN Declaration on Human Rights Defenders to strengthen a lot of the discussions within that, so that the space that it can be an international tool that tends to address a lot of the domestic challenges we are having with shrinking space for civil society actors when it comes to engaging on business and human rights work. I will not go into discussion around the scope because Professor David did talk about it. It's really important that the treaty doesn't lose or does not forget Resolution 396, especially when it was the importance of it, looking at the activities of the transnational character. But when you go to Article 4, especially on rights of victims, this is where a huge challenge comes in, because so many times we forget the power dynamics that we are facing as a continent, but also as different countries, largely because abuses, and I speak from different engagements I've had with colleagues, either from the East African community, but also from the South African bit, and also West African, through the regional engagements we had on the treaty last year. A lot of abuses and violations of human rights in business activities tend to happen in complicity with the state. So you have a situation where corporate actors or business enterprises are violating human rights, but also they are protected by the state in one way or the other. So it's really important that whereas Article 4 strengthens rights of victims, and protects them from unlawful interference against their privacy, intimidation, and retaliation, we have to work around mechanisms that they don't forget that you're dealing with state machinery and agencies that are protecting business entities because they're looking at them as, drivers of the economy, but also players around human capital development. So it's really important that the language that is used around human rights victims does not and it's something that was going to talk about, you know, where you don't forget the state obligation in some of these engagements. You see the new draft losing the use of the word violations a lot and focusing more on abuses, but we can't take away the obligation of the states, the state obligation to protect, to promote, but also to ensure that non-state actors respect human rights. And one of the things that has to be anchored around rights of victims is that state obligation, where we have to ensure there is more attention given to the victims in whatever angle they are, either as indigenous communities, either as either direct or indirect victims in one way or the other, but also not forgetting that some of the abusers in these are the state, and so making sure that the obligation of the state to protect and ensure respect by non-state actors is clearly spelled out within the article. The other bit that has to be clearly and specifically mentioned within Article 4 is the specific vulnerable and marginalized groups that are at risk. And I know I mentioned in the beginning, and fellow Jean maybe will look at it broadly within the gender perspective, but it's really important that discussions around gender within the treaty don't focus only on women's rights, but look at the other dimensions of vulnerable and marginalized groups that will be affected. And a lot of the discussions we've had, even in Uganda, is issues to do with, especially whenever there are business investments or large-scale business investment or development projects in any area, there's an influx of people. There is an increase of domestic violence cases that arise due to, you know, to new money that is entering into a community. There's sex workers that tend to also follow different investment and development projects. But also the challenge, and why I was mentioning it, where I have in my work struggled with, and these are colleagues of mine, especially working with the women's organizations that are very hesitant to engage with sex work because of the whole traditional connotation around it. And so discussions around gender dynamics within the treaty must not forget or must not focus on women's rights alone, but also be able to specify the different gender issues that arise within these frameworks and ensure there is more protective cover for the groups, because there are different risks that arise for different communities, not necessarily women, but also doesn't take away the realities that women and girls face within business engagements, and especially, as it was mentioned, largely due to most of the business and business-related violations and abuses tend to deal with land and livelihood and sustenance, where women tend to, on the continent, tend to survive on mostly. Prevention is another area that really has improved over the years, especially in its provision. Professor David talked about issues to do with human rights due diligence. I agree fully on the challenges with human rights due diligence, where human rights obligations are not very clear. But also one of the challenges that we've continued, because one of the things that we continue to say is that human rights due diligence must be driven from a more state angle rather than from the corporate angle. One of the challenges we face here is that issues to do with environmental and social impact assessment, and sometimes human rights impact assessment, are undertaken by the companies themselves and only signed off by the state. And the argument and the discussion is, in order to have more meaningful and effective preventive mechanisms, these measures to prevent human rights abuses and violations must be undertaken by the state, or there should be avenues for them to undertake some of these avenues to ensure that corporations that fail in their roles are sanctioned, but also there are clear redress mechanisms that are bound, especially when it comes to human rights abuses and violations. One of the other things around prevention that is important within the revised draft and as it's provided for, is the issue around a free, prior, and informed consent as a key tool to prevent some of these business and human rights violations. The challenge that we've had, and I've discussed a lot with my colleagues, it's important not to, it is important not to focus free, prior, and informed consent from indigenous perspective. I will give an example indigenous perspective alone. I'll give an example. In Uganda, we have a more discussion around where the government has stayed away applying indigenous people's, frameworks and stuff, saying everybody is indigenous in this country, but also trying to say what we have are ethnic minorities, but not indigenous people, because everybody is indigenous in one way or the other by virtue of the colonial undertakings. But that's not a discussion I want to engage in. But one of the things that we have always employed is say it's important to look at FPIC principles from an indigenous people perspective, but also maybe borrow in the new direction, let's say the World Bank and other financial institutions is undertaking to look at the context of different countries, knowing that you can say in principle, FPIC principles within the indigenous people framework, but also apply them in whatever context the community views itself. And this is where we come from and incorporate issues to do with right to self-determination, but also looking at how a community views itself from within the principles around free, prior, and informed consent. And I think this would be a huge undertaking within business and human rights frameworks to ensure that in whatever investment or development project that is being undertaken, FPIC principles are respected and are promoted by the state, and not only to be applicable for indigenous people, but to be applicable for communities as long as they're affected or as long as their tenets, the tenets that are clearly specified within the principles affect the community. And so it's important that the text does not focus on only indigenous people, because then some governments will use it as non-applicable to them because they don't look at a certain community as indigenous in one way or the other. Prevention is, I would agree, I would note that the article on prevention has been strengthened a lot, but it's really important that this cannot be looked at as voluntary undertakings only by the companies, but must fall within the role of the state to protect, but also the role of the state to ensure that non-state actors respect, but also the way it is provided within the prevention, the article on prevention is that you find a lot of it has to be done by the companies without strengthening the measures that the state has or the role that they have around it. And like I said, I won't repeat a lot of the things that Professor David talked about, but issues to do with human rights, mandatory human rights due diligence is some avenue that we are trying to push, and discussions within some of our responsible governments is to ensure that, strengthening, how do we strengthen, because, and I speak from reflections with my Ministry of Foreign Affairs around this, saying, irrespective of what is developing on the national, on the international stage, if we can't strengthen domestic provisions around human rights due diligence, around prevention of abuses and violations, that cannot happen. That will not inform a lot of the address mechanism that we're pushing, and there is need to have that incorporated within our domestic laws. The other bit within prevention that is really critical if we are going to have an effective and meaningful remedial mechanism or access, even within the principles of FPIC, are the issues around access to information, because it's really important that access to information principles are available or are enforced within, within different landscapes. We struggle as civil society or human rights advocates to get relevant information to guide our interventions or even advocacy around specific issues. we have had conversations with different actors saying, access to information, how different domestic legislations around access to information speak may not be applicable or there is a struggle around applicability of access to information, of private information that may be in the hands of companies. So it's important that the discussion around strengthening civil society engagements around this does not take away the point of access to information, where civil society needs to advocate, but also empower communities to push for accountability. I know we are really caught up with time, and I will leave a number of these other areas for question time, but also my colleagues will be able to speak to, because the other bit that is really important that also applies to civil society a lot is the Article 5 on protection of victims, and I hope we can speak around that on a different time. But I know I've gone beyond my time, and I wouldn't want to deny the other panelists point to discuss, but we'll be available to take questions. Thank you very much.
Thank you so much, Arnold. As usual, you were brilliant and you covered quite a lot. And I know you still have a lot more to talk about. The points that stood out to me, for me the most, were the issues on human rights defenders and how we can link to ensure that we link the treaty to existing UN discussions and treaties on human rights defenders, and also to think very deeply about the power dynamics and the complicity of states and corporations, and how those dynamics work to prevent states from actually being very firm in building articles, actually protect corporations, and so work against them building mechanisms that work on that. And your emphasis on Article 4 is also very true. On the gender issues, I don't know if Ms. Falajin is on the call right now. Falajin, are you on the call? But I think that you've raised issues for us to also think deeply about vulnerable people, and not just gender issues. And also the context of vulnerability differs from community to community. Also the context of gender and feminist issues also differ radically from context to context. And so thank you so much for that. If Falajin is not here, I'm going to come back to her, and I'm going to ask that Professor Gitu Maigwai, please, if you can unmute yourself to speak to us this morning about pushing for the adoption of the binding treaty, the balance of forces that have a bearing on the treaty process, and prospects for adoption. So Professor Maigwai, you have the floor. Thank you.
Thank you very much, Madam. I hope that you can hear me clearly. I will try and be very brief so that we may allow for participants to call in and make their contribution. From where I sit, I think we have made tremendous progress. I think the recognition initially under the guiding principles that we did need a framework from which, within which to deal with the question of how business interacts with human rights was important. I think the transition now we are about to make, that is the transition from soft law to what some of us would call some hard law, is a very, very important milestone. I've been asked to talk about who the actors are as we continue the dialogue, and what are their various stances, and how can this be reconciled and harmonized so that we move together on this journey. To my mind, I think that the key actors will continue to be the contracting states for obvious reasons. This being in the nature of a treaty, being in the nature of an international legal instrument, the primary actors will continue to be state parties. But that notwithstanding, of course, the business entities are most seriously implicated in the subject matter of this proposed treaty, and therefore will play a critical role, as indeed they have right now. Thirdly, and I think from our perspective this afternoon, the third most important group is the human rights victims, and of course here most represented by human rights defenders. Now, let me say something about states. I think that this treaty in many ways reflects a long outstanding controversy in international law. And that has been a controversy as to the treatment of, or rather the proper subject matter of international law, and whether entities other than states enjoy the same standing, the same prominence, the same interest as states do. Luckily for all of us, when I went to law school a lifetime ago, this matter was extremely controversial. When I returned to academia 2 years ago, luckily, I found that it had ceased to be controversial, and much middle ground has been found. And that is the ground that we, I think, have to exploit so that we can make progress. The states, especially the states from the capital exporting north, have had a softening as regards this issue in a manner that makes it possible for capital importing countries of the South to be hard on the subject. And to my own mind, I think that the momentum is with us. The wind is behind us. And I think that that is a very, very important achievement that has been achieved. One can see, even outside the scope of this treaty, one can see unilateral action by state parties that is very edifying. If you look at California, which I am advised is the 5th largest economy in the world, California has a Transparency in Supply Chains Act. The United Kingdom has a Modern Slavery Act. Australia has a Modern Slavery Act, which is as young as 2018. France and Germany have introduced mandatory due diligence laws. And to my mind, this means that the ideological war has been won. And states on the whole, progressive states, have bought into this. And that will, I hope, help to make the treaty a possibility in our lifetime. But that is not to say that every state or the majority of states are bought onto this. And that is why I think we must flag the question of state commitment to be a continuing concern for if we are to deliver on the treaty. Now, most again, there is, and I think this is a very enduring problem in the context of we in Africa and others of our friends in other developing countries. And I hear this argument from government officials all the time. And I was in government myself for 7 years as Attorney General of the Republic of Kenya. And I heard this argument from my colleagues all the time. And not all of them were hostile to human rights. And most of them would say, look, we are trying to be an attractive destination for doing business. We want to attract international capital. We do not want to create a legal regime that is so difficult to navigate, and that business goes to our neighboring countries or a neighboring region. So I had this countless times. I'm sure it's a position taken by many other countries, and it means that we haven't won completely on this question, and more work needs to go into persuading government, as I have tried to do since I have left government, that it is not business or human rights. We can have both. It's a win-win situation. We can have responsible governments with responsible legal regimes and a responsible business community that treats citizens with dignity and with rights. So that's one blind spot we have to keep worrying about as we go along. But the other one, of course, the key other actors I mentioned earlier are the business entities themselves. My colleagues who spoke earlier have spoken about the shifting target of who the treaty ought to address in essence. And there are many people who would support the treaty unconditionally if it is said to be addressing multinational corporations, and who would have some hesitation if the treaty is addressing all business enterprises. To my own mind, I think we will not succeed if we do not address all business enterprises. And I'm going to give one reason, and there are many reasons, but we have no time to go into that. In Africa and in many other developing countries, state enterprises occupy a very critical position in the market. And state enterprises can and often are the source of terrible violations of human rights in the mining sector, for example, extractives in general. And therefore, if we do not think of the treaty as affecting all enterprises, we will be living out of the sector. Sorry, we will be living out of our reach, very key actors. One of my colleagues earlier spoke about small and medium enterprises. They are a very critical part of the economy on our continent. And as long as we think of the treaty as providing a framework for multinationals that potentially could exempt domestic behavior by small and medium-term enterprises, we will not have achieved the ultimate goal, which is to create remedies for citizens and our people. Now, the third and probably most important group, the victims and the human rights defenders who speak in their name, the real issue here is about access to remedies. And the guiding principles took us only so far. I must say, as a member of the working group, I'm very proud of the work that has been done around the working group. I will be talking about the work we are trying to do in Kenya and in our neighborhood. But I think that we must place victims at the center of what we are trying to do with the treaty. Now, the victims want remedies and effective remedies. That is why I think not everybody probably agrees, but I do agree. I do personally believe that we can only make progress if we strengthen domestic capacity. It is possible to have a very big, a very huge mass tort litigation in a faraway place, maybe Canada, maybe United States, maybe someplace else. But the optics of it are very good. But what we have to deal with, what we have to reckon with, is the day-to-day violations in the places, in the locations where people live. And that is why the domestic capacity is, in my view, absolutely critical. And I understand, and I concede the point made by my colleague from Uganda, that we need to understand that it's not only where the company or the corporation is purported to be or is incorporated, we must also think of where its assets are. And that's why I think that the provisions to the of the proposed treaty dealing with mutual legal assistance and dealing with international legal cooperation are equally cardinal for the effectiveness of the treaty. I think that the victims are concerned, and that the gender dimension of these violations not be lost. I think it's a very critical issue. It's been spoken to. And we in Africa understand exactly why that is such a critical problem. And I don't want to overstate the case. The victims are concerned about data protection. They are concerned about anti-corruption and bribery mechanisms, non-judicial remedies, the protection of human rights defenders. And this is a very critical issue. And most of you may have read about one of the biggest cases we've had in Kenya about lead poisoning in the coastal town of Mombasa, and the years of labor that have gone. The human rights defenders have put into this particular litigation, which has been successfully resolved in favor of the victims in the High Court, but now there is pending an appeal. So that the protection of human rights defenders is absolutely critical. One last thing that I would like to say before I hand over the floor, so that you, Madam Moderator, may have an opportunity to invite other speakers, is that as we move forward, we should caution ourselves, and that we shouldn't be understood to be proposing a treaty that is incompatible with contemporary international law. In my own view, this is our biggest blind spot. That is to say, those who will want to oppose the promulgation of the treaty will raise an argument that states that we are going way and beyond contemporary international law and may be repealing or purporting to repeal either well-established international conventions already in place, or may be purporting to repeal existing domestic law in a way that is in violation, A, of the domestic law, and B, of international law. So we must keep coming back to that point, because it is not enough for us to mean well. We must also do the job well, so that good intentions and good drafting and good negotiations go hand in hand. In Africa, as I close, I am very heartened myself as the member of the working group representing Africa on the working group. I am very, very pleased with what I see happening on the continent. For example, I know that Ghana has become the first country on our continent to participate in the voluntary principles on security and human rights initiative in the extractive sector. I'm very pleased about that. In Kenya, when I served as Attorney General, I recall that in 2016, we became the first country on Africa to commit on a national action plan for business and human rights. And I think that for me is a legacy issue that I'm very, very proud of. I have noted that in Morocco, for example, Morocco has integrated a chapter on business and human rights in its 2018-2022 National Action Plan for Democracy and Human Rights. I note in Mozambique, they are undertaking due diligence and other initiatives to protect human rights and develop a national action plan. I noticed in Nigeria in 2017, the Nigerian National Human Rights Institution and Human Rights Commission and Nigerian civil society were leading on an action plan. My own neighbor here, Tanzania, in November of 2017, Tanzania released a national baseline assessment on the status of the implementation of the guiding principles. And last but not least, Madam Moderator, down there in the south, in the Cape of Good Hope, I know that civil society has conducted a shadow national baseline assessment on the current implementation of business and human rights framework. The same is true of Malawi. And I would therefore want to end by saying that our commitment to the treaty is demonstrated by the other things we are doing around the treaty, not because we don't need the treaty, but because we are preparing the ground for when the treaty is finally ratified. I have spoken to many businesses in our region, and I am happy to report that there are many, many businesses that understand why we need to do this. They understand that their own reputation as supporters of this initiative helps them with their own ranking and standing. And there are several, I was saying in Geneva the other day when we last had our conference, that for the first time in my life as a lawyer, I have found human rights lawyers and corporate commercial lawyers in the same room, not shouting at each other, but agreeing that due diligence is an important tool, and the commercial lawyers need to learn from the human rights lawyers what the trigger points are, and the human rights lawyers need to understand how the corporates are structured and how responsibility can be apportioned. So I think we are living in a good time and in a good space. And I do think that Africa will be the better after our initiative. Thank you very much, Madam.
Thank you so much, Professor Mangoy. And those were very, very deep thoughts and reflections for us to think deeper about. The most important, and which was the premise for which you started, but state commitment, which continues to be a concern at this material point in time. And also that what we need at this material point is responsible government with responsible legislation and responsible corporations who are willing and committed to respecting the human rights of their host communities. You also spoke about the victims and human rights defenders and the importance of access to remedies. You've asked that the cardinal point which we must emphasize on must be on how to strengthen domestic capacity. You've also spoken about the progress which we've made over the years and the language of due diligence, of corporate accountability has also changed over time and its acceptability in our context. You've also pointed out that Africa is not particularly coming in last into the conversation in spite of the great progress that's been made, particularly in Europe. You pointed out the progress made in Morocco, in Mozambique, in Ghana with the voluntary principles, but in spite of the fact that the voluntary principles are not binding, the Nigeria's move towards the National Action Plan on Business and Human Rights, what's going on in Tanzania, in Malawi, and finally that we all need to learn from one another and think deeper about the context and not try to jumpstart beyond what contemporary international law is, lest we be drawn back by those who are finding faults in the first place. Most importantly, you've said that we need to learn from one another. My core takeaway is that we need to build capacity across board. And on building capacity across board, and particularly borrowing from the context of what African states need to do, I'm going to invite Ms. Gladys Pickering to speak with us this afternoon on the role of African governments in the treaty process and the prospects for adoption. Madam Pickering, you have the floor.
Thank you very much, Madam Chair, for your introduction. And I must also add that I am extremely thankful for the presentations given by the other speakers and the insight especially shown or portrayed by the speakers. I would particularly like to commend Professor Mugai on his input and the passion with which he spoke. He covered most, if not all, of the issues that I'm also going to speak on. Of course, I'm speaking as a government representative for the Republic of Namibia, and as you might know, Namibia has been very vocal during the intergovernmental working group sessions on the issue. And we will continue to remain engaged. As recent as November 2019, we had a very successful intervention in collaboration with Lee Day solicitors in the UK on transnational corporations, business, human rights, and we had a good representation of government offices, ministries and agencies, as well as civil society organizations and various NGOs. We had very rich debates, and we realized that we need to do a lot more sensitization on the issue, not just in Namibia, but also speaking from an African perspective. We've realized through the engagements during the intergovernmental working group sessions that there was quite limited participation by African states. Too few African states participated during the working group sessions, and this is perhaps due to various reasons. We have also experienced quite a backlash on the African states and also others who spoke up during the previous working group sessions. Quite a number of unfortunate threats were made against these states, and it takes some more deliberation and certainty to be able to speak on behalf of others who might not be able to speak during such working group sessions. So from a regional perspective, we know for a fact now that we have to collaborate closer with neighboring countries, but with all states in the region, to ensure that those who are unable to speak during the working group sessions and at other platforms, that they are represented in a manner that will enable their views, that will bring their views to the fore as well on their behalf. So that is something which we are currently working on. We need to see closer collaboration between African states, and we will soon be reaching out to see how we can ensure that all states have the same understanding, especially of the latest draft of the legally binding instrument, because there are quite a number of significant changes made and also incorporated since the 5th working group session. And I think it was Professor Bilchitz who elaborated on those changes. I've also, Mr. Kwesi also elaborated on some of the gaps and deficiencies spotted on in the text. So we would like to ensure that African states, we understand what these changes entail, what are the possible consequences or impact of these changes, and how we can, as a region, have states come together to have either states are sovereign, so we do not necessarily have to agree on everything, but how we can better elaborate on the issues raised. Now, when it comes to business and human rights, it is the reality on the ground is that very few places in the world, on the planet, there are very few places where the impact of transnational cooperation and business activities are more visible than in Africa. Adverse impact. There are really very few places in the world where this impact is more visible than in Africa. So we have to look at what is the core of these issues? What are we talking about? What are the barriers that we are talking about that we have to look at as African states if we want to participate more meaningfully, if we want to strengthen our approach towards this or in support of the legally binding instrument. And we have to look at the common barriers, which are the different legal approaches, the lack of legal aid in many African states, the lack of class action mechanisms, limited international cooperation, physical location of evidence and access thereto, and then of course the issue of limited accountability. So if we want to make Africa more conducive for business activities, since we are so blessed with mineral and other wealth, riches, which is so attractive to those who do not have it, what will we do to make ourselves more attractive for business, yet ensure that the message we give to our people, which is supposed to be our most important and valuable resource, to ensure that they know that they are more valuable to us than anything else, yet balancing that with attracting valuable business interests. If we want to ensure that we do not miss any link between those two, we have to participate meaningfully on this draft instrument so that we can make sure, whilst we focus on due diligence, whilst we focus on the duty of states, because states have the primary responsibility to protect, promote, and fulfill human rights, whilst we focus on international cooperation, mutual legal assistance, whilst we focus on prevention more than anything else, we have to make sure that we do not shoot ourselves in the foot and make it so difficult or so cumbersome for sincere investors who are willing to come to Africa, whilst they will observe our human rights mechanisms, whilst they will ensure that they comply with due diligence requirements. We must make sure that we do not shoot ourselves in the foot by putting in place too cumbersome processes that will chase them away. So whilst we do this, we must make sure that we concentrate on the strength of the text to ensure that we do not lose focus in the text. Our perception is that we are watering down the text a lot, which also poses its own dangers. So we must make sure that whilst we do not want to be seen as using this text to be difficult when it comes to investment and business in Africa, we want to make sure that we do not water down the text too much so that it will lose the focus completely. And the focus, of course, of this text is to have human rights over trade. We must ensure that human rights and business go hand in hand. And Professor Mugai stated it so eloquently that it should not be business or human rights. It should be business and human rights. And unfortunately, if we have to meet each other halfway, then we have to agree that other business entities will be included. So if we want to move our shift or look at the prospects of adoption, we have to look at answering this question. What is in it for us? And we will have to be able to answer this question from a state perspective, from an individual human rights perspective, from the business perspective. What is in it for us? If businesses can be satisfied that they will benefit even more, perhaps, than any other actor with regards to what they are supposed to do. If they can benefit more by complying and buying into this treaty, by complying with human rights due diligence requirements, then I think we will have a bigger buy-in. So that question, we must think about it carefully. What is in it for us? Only in the industries or sectors of agriculture, mining, garment, the garment industry, and also, of course, I don't want us to lose sight of the fishing industry. Those industries are regarded as higher risk sectors where human rights abuses and violations are more likely to occur. And in Africa, there's enough evidence to show that indeed this has taken place. All of us can attest to this, and the evidence is available. So when we talk about the issue of how African governments can push for the adoption of the binding treaty, I would say we must, as African governments, we should collectively seek, we must agree that we will collectively seek a world where corporate rights do not trump human rights, where we do not become an unattractive business destination, but that we ensure that our domestic legal framework is in line or should be in line with our international obligations. And if we can together stand together to move ahead with this legally binding instrument, which will form part of international law, then we will, Namibia, for instance, we have a monist approach or monist system where an international instrument which we become a state party to forms part of our domestic law by the mere fact that that international instrument that we are state party there to. So we cannot legislate domestically against that international instrument. So if we can do that, and if we can ensure that we promote the ease of doing business in Africa, whilst taking into account due diligence and human rights due diligence and compliance with our domestic setup, I'm sure we will be able to see this instrument becoming a real value for our corporate entities, transnational corporations, for all of them, as well as for states. Because where is our focus? Our focus is on the individual and the individual human being, as well as the groups that are currently affected by human rights abuses and violations occurring as a result of the business activities of transnational corporations. So with that, I think we must really zoom into also what will be the process when it comes to adoption. We all, of course, know the Vienna Convention on the Law of the Treaties and what it says in Article 9 thereof, and the process that will lead to the adoption of this text. So if we at all want to reach that stage where there's the adoption of the text takes place, we need to ensure that we have more African countries on board, that more African countries can answer that question positively as to what is in it for us, what is in it for our people, what is in it for our economies, what is in it for our environment. Then we will be able to push forward. we are extremely excited about the way and the progress that we've made since June 2014. We think that we've really come a far way, and we should not lose momentum at this stage of the process. It is paramount that we remain engaged, that we all understand the provisions of the new text and how it came about, and that we should collectively seek to move forward. And we must focus on the philosophy that has led to this initiative, which is the principles of equity, legality, and justice. And we must think about the impact that it will have on the human rights, the enjoyment of human rights by all people, not just in Africa, but in the world, and also the protection of the environment and how we can benefit, our economies can best benefit, because currently, unfortunately, we are not benefiting in a way that we can really say we are really the richest continent on earth. Thank you very much.
Thank you so much, Ms. Picking. That was brilliant. And I think you ended on a very important note, that we cannot boast of our wealth in spite of being the richest continent on the earth. You've also pointed out that we need more state actors engaged in the process, and that states must rally together to ensure that they carry along other states and amplify the views of those who are unable to speak out at such forums. You also pointed out that African states need to bear in mind particularly what their views are, what our common barriers are, what our legal structures as well. For example, the lack of class action mechanisms on our continent. And more importantly, that our focus should not be business or human rights, but business and human rights. And that involves us seeking out sincere investors. Sincere investors will respect the rights of the host countries and the host communities in those countries. And you also pointed out, of course, the very importance of vulnerable sectors of the economy, which must also take on due diligence and think about binding legislation, and that our legislation must not take us away from being attractive sports, but from being responsible states. I will take away particularly your point about being responsible states in Africa, finally being able to boast of its wealth, not just in terms of its natural resources, but its respect for its own people. Thank you very much. And we're going to go very quickly. We're going way out of time, and I hope you'll be patient for the conversation that will follow afterwards, and we'll try to limit that. But Ms. Falojin Amuno is in the house, and we've spoken quite a bit, alluded to gender issues in the course of our conversation, particularly with Arnold and Professor Moigai. Well, Falojin is here, and I hope that she will take the conversation forward, speaking on the gender perspective of the second revised draft. Falojin, you have the floor.
Thank you so much, and apologies for coming late. I had an issue with power, which in the context of Africa should be welcome. But then I just want to quickly speak on the feminist perspective, but also to welcome the second revised draft. I think this comes at a very important moment, which is couched on the COVID pandemic, which is a health pandemic, but for Africans, it's largely going to be an unprecedented economic setback for us. And so at the heart of this is also the role of corporations, particularly transnational corporations and their supply chains, and how these have contributed to abuses and violations in the continent, and particularly industries that are precarious and are often held by women and gender non-conforming people. And so prior to different years, I think it's quite critical in terms of how we look at this document, how we look at this process in terms of advancing corporate accountability. In terms of the feminist perspective, I represent a coalition called the Feminists for Binding Treaty, which is a coalition that has been working collectively since 2015 to ensure that we incorporate a strong gender perspective in both the process, but also the content of the binding treaty. At the heart of what we advance is that this document should really address and seek to prevent impunity, corporate impunity at the highest levels. Having said that, and I think a few speakers may have alluded to this, there has been steady and very incremental steps towards this, but largely we feel that there is some improvement that really needs to be done in terms of incorporating safeguards that integrate a gender responsive approach to both protection, remedy, and legal liability in this document. I think at the top of what we feel, first of all, is there's silence on the role of states, particularly in terms of how they are complicit to some of the violations that are held in corporations. And I believe the previous speakers may have largely spoken to that. Secondly, we feel that the preamble can be made stronger. I think this is something that we have been pushing quite a bit in terms of how to incorporate that. There are already agreed international human rights law, and we feel that while some have been incorporated, including CEDAW, the Beijing Declaration for Platform for Action, we feel that it would be clearer if we can include a bit more language around measures that encompass what this means for the operations of corporations. And so unpacking how these conventions can be integrated in the planning phase, in the due diligence processes, and further operations. We feel that how it has been placed currently leaves it quite open to interpretation, and I think the lawyers in the room would be able to speak more to that. Secondly, in terms of rights of victims, I think there has been progress, especially in acknowledging that they're right holders, because I think one of the things we push back in terms of language and the political potency of how we name survivors and right holders has been something that the Feminists for Binding Treaty has been calling for. And so we can further strengthen this by ensuring that we also unpack this further, because we know that there are very gender-specific abuses that happen in terms of corporate impunity. And this happened before, during, and after proceedings. And so unpacking this and acknowledging that will prevent re-victimization in the course of proceedings, especially in the cases for access to remedy. And the access to remedy, we've also been pushing for a bouquet of approaches. I think it's quite important in the context of Africa, where our culture is quite patriarchal. We often use the example of land, where only 2% of women own land. And so if we purport to say that, remedy is in the form of land or redistribution or transferring land, then we do know that there's a loophole in terms of how this can be justice, gender justice. And so contextualizing some of these articles, particularly to the challenges that we face in Africa and African societies, is something that the Feminists for Binding Treaty has also been pushing for. In terms of Article 6 under prevention, we find that we talk about the human rights due diligence and the need to include a gender perspective, particularly in consultation with women and women's organizations. This is particularly important because now I think we are also in the age of data and data collection. And so we are proposing to add a clause where we include women are involved in the processes of collecting data, but also the data is disaggregated by gender and other categories. I think this is quite important, again, speaking to the gender-specific violations that happen in the context of corporate accountability. Largely, I think what we feel is that, particularly when it comes to the gender perspective, is that there has been quite a bit of steady progress in terms of incorporating our asks. So these are under reparations, to victims under violations, and particularly in talking about gender responsive access to justice. But for us, as the Feminists for Binding Treaty, we feel that this document, and I think this is why this conversation was quite important, is that the process of getting a treaty is a vehicle to gender justice and addressing corporate impunity in the continent. We believe that alongside this, there has to be a collective power of people that can actually invoke some of these clauses. And so for us, it's quite important that while we are focusing on the UN processes, how are we democratizing this information? Because at the end of the day, this is about the lives that will be affected, but also how do we actually see justice, not just within this tool, but knowing that justice is also held by the people. And so going forward, I think our recommendations, we'll be able to share a document in terms of the recommendations. There was a conversation with the ambassador, and I think the next steps of negotiations begin with proposing key language and key text for the documents, which we have done as a group. But for us, we feel that particularly in the context of 2020 and everything that is happening around the world, there really needs to be more stringent measures put in place to address corporate impunity. We are not short of examples of how accountability has fallen far short from where it should be. But then particularly we know that women, gender non-conforming people, and vulnerable groups are always the first to be impacted by these decisions. And so I think I've run out of time. I can see I'm being signaled, but then we'll be here for any specific questions and to circulate information that's helpful.
Thank you so much, Falojin, and thank you for giving us that very compact view in very short time. Needs to leave, and I thought we'll give him 5 minutes to give us his final punchline, and then we can go on to a discussion with the issues that you, the audience, have raised. And thank you so much for being patient. So David, if you are here.
Yes.
If you're still here. Yes, please. Thank you.
Thank you very much, Abby, and also to all the other speakers and presenters. And obviously really important to develop common African positions around the treaty and the questions that are arising. I thought I did briefly, but it's difficult to type out comprehensive responses. So there were a few questions that I thought I would just address. There was a worry about the treaty being addressed to states and not corporations. In terms of the obligations being upon states and not on corporations, and I have posted a brief response in the comments, just to say this is not a fatal measure. There's a sort of indirect model that's adopted in international law, and so the states are essentially assuming obligations to impose frameworks and obligations on the corporations in a sense. And of course, it does lead to strange issues. So like the Ogoniland cases, the Sirac cases, you'll end up suing against states for violations by corporations. And that's a worry. And it might be one of the reasons, for example, that we can answer, Gladys Pickering's answer to some states of why they want to get involved in this, that they don't have to assume responsibility for what states are doing in some senses, what corporations are doing. Someone asked about the draft articles on state responsibility, and the issue there is what really can you attribute, it relates to the point I've just made, can you attribute the conduct of a corporation to the state? And there will be some cases where those will apply. So, in cases where the individual person exercises some kind of governmental authority, for example. But in general, the principle is that conduct of private persons is not attributable to the state. And so this raises the question of again, placing the state taking responsibility for violations, which it may itself not it may have not fulfilled its obligations. And the question is, what gap exists in the treaty here? The state does have an obligation in 6.1, which is quite a broad obligation, to take all necessary legal and policy measures to ensure that business enterprises effectively respect fundamental rights. So if there's a violation, does it mean that there's a failure to provide legal and policy measures? Or if you can't bring a case in that state, does it mean there's a failure to protect the people in that state? So these are all kinds of questions that arise from this. Again, if you want to use the treaty as a basis to go against a corporation, you can't really do that. It has to be enacted through the state law itself. There was a question about supply chains, and supply chains, it's a very important question in globalization that is of business, and that is addressed in the treaty. It's obviously one of the core things. It's Article 8.7, and it leads to an allowance for companies higher up in the supply chain, or companies, parent companies and subsidiaries, to be sued effectively on the basis, or to have liability on the basis of controlling the companies further down, or being able to foresee the risks of their operations. I think this article has actually improved, although it perhaps can be broken up a little bit to make it clearer. There was a question also about rights for corporations and obligations. There was a kind of worry that by recognizing obligations on corporations, we'll somehow give them rights. And it seems to me that is a worry that some NGOs have raised as well, and some have actually opposed human rights NGOs' direct obligations. I think there are a few responses to that. The first is that rights, this treaty isn't about recognizing corporate rights, it's about recognizing corporate obligations. And I don't think it's an automatic kind of inference that once you recognize obligations, you necessarily recognize that the entity, for example, has rights. But in reality, actually, corporations are recognized as having rights in many countries, and including in South Africa, although they recognize as having derivative rights in a sense from individuals. And that may in fact be a defensible position in some sense, because the corporation, essentially, if you don't recognize some kind of corporate rights in some senses, you may leave the individuals unprotected. So it might be actually in a derivative sense quite important, although not recognizing those rights as primary. And I think once you recognize that any rights corporations have are derivative, that they ultimately are individual rights, then you recognize the basis for their obligations, that they have obligations to the individuals underlying them, and also other individuals as well. And also, it's important to put it in context of the fact that at international law as well, many corporations have been given rights and no responsibilities. And so the core thing about a treaty like this is really to rebalance the international system, to avoid a notion that corporations have rights in investment treaties, for example, against states, but they have no obligations to the people in those states, and that the states can't claim under human rights law a protection for certain obligations in order to, in a sense, counteract any rights claims that those investors may have. So those were a few points that I picked up in the chat, and that I thought I would just very, very briefly address. I'm sorry, I have to leave. I have another presentation and commitment. So I thank you very much again to all the organizers for this interesting forum, and look forward to continuing the engagement and discussions.
Thank you very much, David. I think we have lost our moderator, so I'd like to ask if Benjamin can perhaps moderate until we get Abby back on the line. Thank you.
Yes, I can also see that Abby is no longer with us. I will be checking also, please, Turina, check if she's trying to get back in the meeting. So in the meantime, I don't know if one of the speakers would like also to answer to some of the questions that were asked in the box, the conversation box. So maybe I will start by Arnold. Or any of you, if you have any comment, yeah, you can please go ahead.
Okay, thanks, Benjamin. Sorry. Questions that I had attempted to answer them from the chat. Unfortunately, I was logged off, so I can't see specifically on that. But one of them was really answered by Professor David. There was a question around why our states are not businesses primarily responsible for human rights violations, and I did post a response to the person who asked it, but also Professor David did answer it. But one of the things that we have continuously said, the role of the state cannot be relegated, especially in situations like this, because there are power dynamics already with corporate capture and so many things, but also not forgetting that the institutional frameworks that we have, both mechanisms, both regulatory standard setting and also remedial state institutions, and changes of putting, not like there's no primary responsibility of the businesses for human rights abuses, but it's important that the state does not relegate its mandate, but also all is anchored within the mandate to regulate, but also to ensure that the private actors respect. And it, for me, it doesn't take away the responsibility from states. And one of the things that needs to be amplified is that under the provisions of respect for human rights, respect for human rights that the state is responsible for, there is that and certain provisions that they need to undertake, but also development of different policy frameworks that are geared around respect for human rights, but also promotion and putting in place measures to address any kinds of impact that may arise. There was also a statement, I think, I don't know if it was a question around engagements during the process so that we have a treaty that speaks to the African context. One of the things that I've always said, and the challenges that we did face as civil society, and I know Miss Gladys did mention it, and the challenges that we did have was the lack of engagements from the African perspective, especially from government agencies and government representatives, but also knowing that we have always had this reference to a certain treaty does not speak to our context, or a certain international framework does not address challenges that we face as a continent, but also as different countries. And I think the development or the discussions around this treaty gives us an opportunity to engage effectively and to engage relentlessly in all kinds of sessions, but also in all avenues that are provided, so that at the end we have a treaty or an instrument that totally speaks to our perspective, but also addresses our context issues. Because at the end of it all, whatever timeline it might be given, whenever it is completed at a certain point, or whenever it comes into completion as an international framework, it will be able to bind different parties that ratify it. And the challenge we do also face in some of these avenues that we tend to see a lot of these instruments used in other negotiation, international negotiation frameworks. So the importance of engaging meaning
Since we may have lost Kwesi momentarily there, if we could just go on then, Professor Mangwai, your closing statements and the responses to the questions that have been raised. I'm sorry I was thrown off the call by an inept internet corporation, so but I'm back now. Thank you.
Thank you, Madam Moderator. I think one question was directly put to me, and that was a question about my reaction to the conduct of the United States government relative to conflict minerals and the legal and regulatory regime around that. And, I want to say that from where I sit, it is very regrettable what has happened in that context, but even more regrettable that the world has lost the leadership of the United States on these questions. And there was a time when the United States was a very, very strong ally on this question. However, we must work with what we have. And as a closing remark, I wanted to talk about one forgotten ally that we have, whose voice is becoming louder and louder. And these are the investors in multinational corporations. And they are speaking more loudly globally that they do not wish their money put in businesses that violate human rights across the world. I know, oops. Have I been cut off, madam? Can you hear me?
No, I'm sorry, I was cut off. Yes, we can hear you.
Yes, I think that this is an area, this is a group we must bring on board. And in various boardrooms in Europe, in various annual general meetings across the investor world, we are hearing more and more support for corporate accountability before investment, but that is by due diligence, during the lifetime of the investment, and accountability in the event of any violation of human rights. And I think we ought to build on those relationships. Thank you.
So much, Professor Mangwai. I will now go on to Ms. Gladys Perkins, if you will kindly just, well, there's a poll going on right now, which is meant to come at the end of the webinar, which is a resource for the ACCA Secretariat to weigh the relevance. And so we invite you to participate in the poll. But while that is going on, I'm going to invite Ms. Gladys Perkins to round up on our thoughts on government's participation, and then we go on to Fallow Jean. Okay, Ms. Perkins.
Thank you very much. And I just want to say in conclusion again that I believe now we have a great opportunity to come together as African states, and we have an opportunity as governments to collaborate and come up with a very well organized and coordinated approach towards this legally binding instrument, and to make the world know that Africa is serious about protection, promotion, and fulfillment of human rights. And we are also serious about good investment opportunities. We are also serious about productive economic activity, and we want to do business. We want to have investors come to Africa, but we also want to have the rights of our people respected and promoted by all, not just the state, but also by those who come to do business with us. Thank you.
Thank you so much, Gladys. And finally, Fallow Jean, your final thoughts. I know we rushed you through your presentation, but your final thoughts, please.
No worries, no worries. So my final thoughts will also tie into Hank Smith's comment around the African context needing to amplify local customary protections. I think for this, we really invoke, from a feminist perspective, the dangers of retrogression of rights, because we take pride in our African culture, but to the extent that is not gender discriminatory. And so realizing to what extent culture forms additional discrimination and barriers faced by women and marginalized groups when they are trying to seek remedy and pursuing of justice is something that we need to debate, especially when we are thinking of advancing an African response to the binding treaty. Our position really is that the treaty should remove gender-specific barriers, especially those that are upheld by patriarchal social structures and power relations. And often this includes linguistic or cultural and even physical barriers to justice. And I think just carrying the heart of what the feminist perspective is that the treaty, at the heart of what the treaty is trying to do is really address and compel states to take appropriate measures that will transform institutional structures. I think this is what the previous speakers and fellow panelists have really been emphasizing on, and how this can address discriminatory laws and social practices that undermine participation and access to justice of women and affected communities. At the end of the day, the Feminists for Binding Treaty and the perspective is that this tool should go further and cover the highest form of, and address the highest forms of corporate impunity. And this, you know, as we debate and continue to make a formidable position as Africans, would include unpacking who are the different actors and how can this be compelled in these processes to be accountable and responsible. So thank you.
Thank you very much, Fellow Jean. I take your points about ensuring gender responsive access to justice should be one of the most important takeaways in the development of the treaty. Arnold had also pointed out that we need to think the different contexts of gender and also of other vulnerable groups, including persons with disability and children in our context, particularly as Africans in the context of the different sectors in Africa. Now, we're way beyond the allotted time for this webinar. We're 12 minutes beyond time. I want to thank the speakers for very brilliant presentations and for giving us a lot to think about. The first two speakers, David and Arnold, have given us thoughts about the gaps in the treaty draft. And then we went on to Professor Mongai, who emphasized on the need for building capacities and ensuring that African governments are on board in their political will. And we then went on to Ms. Pecking, who spoke about the fact that we need more African states on board. We need to ensure that the network of African states also face the other issues of the views of those unable to speak and amplify their voices, look at the barriers the common barriers that we have and the lack of class action and other mechanisms that may inhibit us from effectively utilizing the treaty in our context and ensuring that the treaty speaks to a specific issues as a continent and that our emphasis should not be business or human rights, but business and human rights. And finally, Fellow Jean spoke very brilliantly that COVID has given us a context to also think deeply about the issues of the most vulnerable groups and how the treaty advocates for them to be treated. She's asked for us to think of gender responsive access to justice in the context of the treaty and the democratization of information. So I thank you again for this very thought-provoking conversation this afternoon, and I'm going to hand over to Ben for the closing remarks on behalf of the Secretariat. Ben, please.
Thank you very much, Abby. And first of all, I would like to thank you for the brilliant way in which you had moderated the session today, the discussions today. I would like to thank all the participants, to all the panelists first. I would like to really thank our partner Carls on this specific event. Thank you, Professor Tshepo for being and staying with us. I know you are very busy today, especially. Thank you, Sandile, from CALS as well for the collaboration on this work. And I would like to thank all the participants to the webinar. We had a very good number of participants. That shows how this topic is very important, very relevant to us here in Africa. And I'm very glad that the discussions went very well. Je voudrais aussi remercier les participants francophones. C'est vrai qu'on ne
In the same vein, I want to thank francophones attendees.
Vous soyez là, j'ai vu certains.
Yes, you've been there. A number of you were there.
Parce que ce webinaire, comme vous le saviez,
because as you know, this webinar
retransmis en français.
Is translated into French.
Really, thank you all of you. And ACCA is still working with its partners on the treaty process. And we are having in the next weeks, especially precisely on the 20th of October, we will be having a workshop, but we will share more information on that in the coming days. And again, thank you very much, all of you, and have a great afternoon. Thanks.